Hi, I'm Hannah Denton-Jones from Refreshing Law, and this is the second in a series of 2 sessions looking at the law of constructive dismissal. In the first session, we looked at fundamental breach of contract as a key ingredient to enable an employee to bring a claim for constructive dismissal, either for breach of contract or for unfair dismissal. The second ingredient that we're going to have to look at is whether or not the employees accepted the employer's breach of their contract. Now, the Geese case tells us that the contract doesn't just automatically come to an end when the breach occurs. The employee has to accept what the employer has said or done as that breach of contract. And so we need to look at the employee's actions and what they've said and what they've done to interpret whether or not they have actually done that and accepted it. Now, of course, in real life, things are often ambiguous. People say things and you're not really sure what they mean. It's not a question of the employee having to do anything particularly formal as such to accept the breach, but they do need to make it clear to the employer that that is what they are doing in some shape or form. So often in cases there's some dispute about that whole area, and in particular things that happen perhaps in the heat of the moment, where we need to be sure whether or not somebody's reaction to something is actually the way that they feel. I had a situation recently where an altercation had happened in the workplace and one of the employees stormed off following that altercation. At the point of them leaving, you're not 100% sure whether they are meaning to come back in tomorrow when they've calmed down, or whether or not we're ever going to see them again. So we have to wait a couple of days and see what happens. Perhaps they come back, perhaps they're contrite and they want to talk to you about the situation before we accept their behaviour as being their acceptance of a breach of contract. There may be lots of other things going on in a situation, and it's not the case that the breach of contract has to be the reason for leaving. It has to be a factor in what's going on. So there might be some other things going on as well, but as long as it's there in the mix, then that will be enough. The third ingredient that we then need to think about is affirmation. And essentially what this means is that it's possible for somebody to waive a breach of contract. So the employer behaves in a particular way, they breach the contract. If the employee continues to turn up for work, or maybe they're off sick and they continue to receive their sick pay, they continue to turn up and do their job, they carry on, if you like, with the employment relationship, the employer carries on paying them, all the things that you'd normally expect to be happening in that relationship, then they are going to have waived the breach, because they're acting as if that contract is still being performed, and in effect are then deemed by the law to have waived whatever the breach was, the problem that occurred. So for an employee, it's always a real challenge. They have to react to the breach. It doesn't have to be immediate. The law is quite generous to employees in that it recognises they might need some time to think about what to do. It's a serious situation. They might want to take advice. At the end of the day, their mortgage and their ability to pay might be on the line, but they can't leave it go forever. And there have been lots of cases where employees have left it too long and have carried on and looking at all the facts and circumstances of the case, the judges have taken the view that they have affirmed the contract or waived the breach that has occurred. So it's always a dangerous position for the employee to be in. They need to be making it clear, really, that they are reacting to the problem that has happened. If you've got any questions, it's adenton@refreshinglawltd.co.uk. Thank you very much.